Sri Desai also comments some additional inputs to the Judicial Standards and Accountability Bill 2012 and says that accountability must also include an omission on the part of a judge to respect and follow a binding judicial precedent. If he fails to do so, he should be held guilty of misconduct and dereliction of duty. There are many other useful suggestions in Mr. Desai's agenda for speedy justice. I congratulate Sri Desai for the refreshing thought he has bestowed on a topic which has become banal, that is boring, by stereotyped approach so far. The public cynicism that loss delays have engendered might assume destructive proportions. Cynicism is a destructive emotion. Unquote. Now, this is how the former Chief Justice of India also has been impressed by these unconventional views. Law is predominantly like a railway track and not just a guideline. The mandatory provisions and binding precedents which interpret the law, forming the flesh and blood around the skeleton, are similar to railway tracks to bind the judicial train to travel only on the track. A lawyer, in his capacity as a railway map reader of the tracks, can guide the public to decide whether a track is available to reach the destination by train, and if so, which train is to be boarded and at what cost, and the probable time it might take to reach the destination. The directory provisions are like guidelines which can be crossed by the driver of a motor vehicle temporarily from the left track to the right track on the highway for the purpose of overtaking the vehicle in front and come back to the normal track on the left, that is in India, and on the right in the US, etc. That is why the Honorable Supreme Court has laid down the law that judge enjoys discretion only with regard to procedure, punishment, and costs of administration, and not with while deciding substantive rights. This was laid down in Umadevi Nambiar versus Seedhan, dead, reported in AIR 2004 Supreme Court Weekly 1385. There is also another yes. Precedents promote certainty in its absence, lawyers would not know how to advise their clients. This is reported in AIR 1990 Supreme Court 261. The name of the parties is Sundar Jas Kanhayalal Bhatija Prahalad Hiranand Advani versus Collector Thane. No doubt, in the higher judiciary, predictability of judgments might become slightly less, as there is a possibility of a larger bench overruling smaller benches' ruling. The higher judiciary is like a railway track laying and repairing machine, which can be seen in the illustrative video. Such occasions arise rarely, but even here, if the higher judiciary applies the principle of prospective overruling of well-established citations, it would go a long way in preserving predictability. Justice Oka Subbarao, a highly respected former Chief Justice of India, had applied this doctrine in some of his rulings, as he was acutely aware of the importance of predictability of judgments to guide the society in arranging their transactions. In recent times, this doctrine is applied in State of Manipur versus Suraj Kumar Okram, reported in Laws Supreme Court 2022 Volume 2 Supreme Court page 4. Otherwise, what should happen to the passengers who boarded a train from Chennai to Mumbai, and middle of the way the railway administration tells them that the track to Mumbai is removed, removing the track which was already there when the journey commenced middle of the way, and judge overruling a citation, a binding citation, retrospectively are similar in operation and in effect. By reading down, reading into, and striking down enacted provisions, the higher judiciary is expected to repair the legal tracks or lay new tracks to enable the rest of the judiciary, including the unofficial judges called lawyers, to faithfully follow. The next point is how to deal with bad laws. No doubt, as Gandhiji had stated